Buonasera, welcome everybody. Thank you for joining us for the talk of tonight, which is, as most of you will know, is part of our lecture series, the Incontri a Palazzo lecture series that we host every Wednesday afternoon. It gives me particular pleasure to welcome Professor Papa to this Incontri a Palazzo series. I'm not welcoming him to Stanford because he's a good friend of the university. He teaches a great class on images of evil in criminal law, and in fact the topic of his talk tonight is along the lines of the class that he teaches for us. His friendship with Stanford University goes back a long time. In 2010, when we celebrated our 50th anniversary, the program was founded in Italy in 1960, we had a 2.5-day celebration, and he welcomed us, all of us, at the Aula Magna of the University of Florence in his capacity then of Prorettore, Vice President of the University of Florence. Professor Papa holds a law degree from the University of Modena and a PhD from the University of Florence, where he is full professor of criminal law and comparative criminal law. He served as Dean of the Law School and Vice Rector, as I said, of the university. He's also been visiting professor at Columbia Law School. He was also there rather recently, and Georgetown University. He's co-director of the main Italian criminal law treaty called Trattato di Diritto Penale. He's a member of the editorial board of the law review Criminalia and co-director of the series Quaderni di Diritto Comparato Internazionale and Europeo, published by Giuffre, which is a very well-known publisher to all doing law and jurisdiction in this country. He's a member of the board of directors of the International Institute of Higher Studies in Criminal Sciences and of the scientific board of the Master's Program in International Criminal Law at the United Nations Interregional Crime and Research Institute. He has also been a scientific consultant for the United Nations and for the European Union Commission. His present research interests focus on the theory of comparative criminal law, on law and semiotics, and on the development of criminal responsibility paradigms in the social and normative context. He has published extensively in his field, and there are way too many books and articles for me to read or to mention. You can Google him, but let me just mention one, which is the Lezioni di Diritto Penale Comparato, which he co-authored with other colleagues and came out in 2013. I know you will join me in giving Professor Papa a warm welcome back to Stanford in Florence. And if I recall correctly, the last time we were on this stage, it was a few years ago, last year, 2014, the very controversial case around Meredith Kercher's assassination, one involving Amanda Knox, came to a verdict. And I asked Professor Papa if he could address the students about it. We wanted to know what was going on, who was right, who was wrong, and talk a little bit about it. So he invited a colleague of his who had followed that proceedings as well, and they gave a talk to the students. So welcome back, and thank you again for having accepted my invitation for this talk. Grazie tanto.
So thank you very much. I would like to thank Stanford in Florence and Director Linda Campani, my good friend, for his invitation to give a talk on the topic Images of Evil in Criminal Law. It is a wonderful opportunity for me, but it's also a very serious challenge. As a matter of fact, I have to squeeze in about 45 minutes a topic which, as a research project, has been keeping me busy for a while, and a topic which has been also the subject of two courses, as Director Campani mentioned, first at Columbia Law School and also here at Stanford in 2014. A topic on which, nevertheless, I would never dare to consider myself as a competent specialist. And I think that you will realize it right away. Images of evil in criminal law is a teasing title, is an appealing title. But it's also, to a certain extent, and it will be tonight, also a kind of misleading title. So it's much more a teaser than a concept frame. I will disappoint the audience saying that, at least today, this title will have little to do with the very concept of evil, with devils, demons, witches, or freaks of any sort. So we will not speak about, these kind of things. And images which represents forms of evil. These are some of the most famous: Goya, witches, Sabbath. Or we will not speak about another very popular topic, which is representation of justice. Symbols, pictures representing justice. So I just, nevertheless, I put in the presentation some of my favorite images concerning these topics that I will not cover. So this is the Judgment of Isis, and this is another representation of Lady Justice. This is Raphael, Lady Justice. And this is probably one of my favorite. Is a representation of justice in a very abstract way, and is at the U.S. courthouse in Boston. And this balance among these panels gives you the idea of fairness, of balancing things, of justice. But as I said, we will not speak about that. Just a word on evil. We will not go into the concept of evil. And now the discussion about the notion of evil is function and the distinction from concepts like wrong, bad, unlawful is very essential in my project. But for what I'm going to say tonight, this evening, we will just consider that evil is equal to wrongdoing. So images of evil will be just images of doing wrong. Of course, the emotional component of the notion of evil is very important in the way pictures work, since they ask for a response from the reader. But unfortunately, tonight, we will not be able to cover this issue. So we will concentrate much more on images of wrongdoing, which is also closer to the very content of the criminal law. Now, the topic, connects us with a much more deeper and complex issue, which is the relation between normative systems and visuality. So this is the broader area where the topic images of evil is located. And I would like to say something about this relation, the relation between normative systems and visuality. What does that mean? Well, in the first place, with normative systems, as you will see, we refer not only to law, but also to morals and to social rules. On the other hand, on the right side of the slide, you see what could be an articulation of the concept of visuality. On the one hand, we have the visual culture, what I call the visual culture, which is made of images, icons, videos, movies, theater, on-screen communication. But also, a deeper and to a certain extent wider concept, which is the concept of visual thinking. Visual thinking is not limited to pictures, to images in the strictest sense, but has to do with imagery, so to the production, to the generation also of mental images, which, can be vehiculated by realistic narrative, for example, and by figurative language. So we will see how this relation works. So we may face this relation asking ourselves a couple of questions, a couple of basic questions. And the first one is how and whether visual culture interferes with the goals of the normative systems. So the development in the technologies concerning visual culture, for example, do they interfere with the way justice works, with the way normative systems work? Is this development in the typology of visual culture helping justice, or is to a certain extent frustrating the goal of justice? And the other question has to do with the visual thinking. And so how visual thinking, how this production of not only physical, literal images, but also mental images, interferes with the genesis, with the formulation of rules, with the way we conceive and draft prohibitions. We will be, of course, more specific in a minute, and we will see some examples that will make our conversation more concrete. So let's start with the concept of visual culture and the relation between visual culture and criminal justice. As you know, law has traditionally been about words. So legal texts are made of words, and trial testimony and oral arguments, jury deliberation, everything has been traditionally about words. Now, as never before, it is also about images displayed on screens, like videotapes, digitally enhanced crime scene images, and computer animation. These are new images, new forms of visual culture. And as I'm trying to articulate the various kinds here, we have multimedia displays combining photos and videos, drawings and diagrams, sound of witnesses' voices. Everything can be mixed together and put into one audio video to address, for example, a jury in a trial. So let's see how it works. This thing started more or less at the beginning of the 90s, and this one that I'm going to show is the first. They say it's the first example of an audio video which was supposed to address the jury within a trial. You see, it's very slow, but just a few seconds. You see, the quality of the image is very primitive from the kind of sensitivity we have today. But nevertheless it interested. So we have to think that this is not something that works, that has been showed at a TV show or at a talk show, but is something that was intended and was actually showed in a court of justice. And but now from this quite primitive example, we go to something completely different that we have today, which is something that this time is worthwhile to watch to the end. This, again, is a way of presenting evidence at the trial. So these are two cops that they come to the scene of a burglary, of an attempted burglary, and they fire at these people while they were running away. Okay, so as you see in the details of the movies, we have, for example, an expanded image of something which could be a gun, and that the burglar was holding in his pocket. And this is a very crucial point in order to establish, the self-defense, for example, from the point of view of the cops. Did they have reasonable grounds to believe that that guy was ready to fire them, to shoot at them? Now, of course, the way you represent the interaction between the cops and the burglars is essential in order to establish whether that, the possible argument is sound, whether they were reacting in self-defense or not, whether they made a legitimate use of firearms in order to stop the commission of a crime. This is probably, the next frontier, and the name is Oculus Rift. I don't know if you are familiar with this name. Well, this is really a virtual reality system, which, by the way, has been developed and on which the very serious research is carried out at the moment by the Virtual Human Interaction Lab at the University of Stanford. And these systems allows you, to reproduce with absolute fidelity the scene of
Para enfrentar la situación que hemos visto en el reportaje anterior, tenemos una muestra parcial del tremendo problema que tenemos con la seguridad ciudadana. Hay que hacer muchas cosas. Tienen que intervenir los vecinos.
There you go.
So what would be possible is to carry the jury, the judge, and litigants, around the world, in principle, back to the crime scene during the crime. So to recreate the situation of the crime scene, and also to be able to evaluate not only what happened, but also how reliable the eyewitnesses could be, since you can place yourself in the shoes of everybody which was present at the crime scene. Now, this is the basic question. Are these new forms of visual culture good for the law? Or they are very risky in respect to a good number of basic principles of criminal procedure, for example? I think that this is a very open question. And I have some ideas about it, and I would like maybe afterwards to discuss that with you. But the issue, it's very different. Well, first of all, why it could be something very good. I think it has to do with the fact that at least the criminal procedure is very much related to the idea of truth. And so whatever can help to, reconstruct, especially through a vision, what actually happened, is no doubt helpful for the achievement of truth. So this is the other. This is but an immediate objection to this argument is that, at least in the criminal procedure, civil procedure is different, but you do not want to achieve truth at any cost. Truth is something that has to be achieved according to rules, and rules are there, rules of procedure, are there to protect individuals' rights. So not truth at any cost. So how does it work? How does this new technology interfere with the idea that truth is important, but it's not truth at any cost? And then you have, so in this aspect, you have a problem of friction with fundamental rights and with the idea of conventional truth, which is not a bad idea. I mean, it's the idea that truth can be a result of applying rules. Now, you also have an issue of reliability and an issue concerning the way this kind of evidence impact on the final decision of the adjudicators. Seeing is believing. Images are capable of inducing belief much more intuitively and effectively than words. They are capable of producing cognitive and emotional responses similar to those aroused by the real thing depicted. They tend to be accepted as highly credible evidence of what they picture. So this is why images have such an incredible power of response. Visual culture, images, they induce a kind of naive realism. In other words, knowledge that we acquire through images is attributed directly to the features of the world and not to the ways we come to know it. So when a picture mirrors something from reality, we tend to believe as real to the object of the representation. We don't reflect on the ways we come to know that picture, which is through the medium, pictures, video, and whatever. So meaning, the very idea of meaning is understood as identical to the content of the picture. So in other words, critical thinking is sleeping very often when we watch images. Also, the new digital images, digital images in particular, and I can imagine also the new technologies like the one that we mentioned a few minutes ago, in which we have the ability to recreate completely a given environment, placing ourselves exactly within the scene of something that happened maybe 2 years ago. We tend to lose our awareness, so to say, of the frame. A frame is something that, when we have a painting, a picture, that tells us that that is not reality. The frame is whatever separates a representation, an image, from reality. And it's very important that we are aware of the existence of the frame. Otherwise, we will not be able to carry out any critical thinking and to evaluate what is exactly the meaning of what we are watching. So I think also that in this respect, it makes a huge difference whether you are trying to use the audio-video or the new technology in order to carry out an argument, so to develop your argument in court. So this case can be called as a demonstrative evidence, demonstrative arguments. It's not very different, at least to a certain extent, to the rhetoric of an oral argument. You can use, all kind of devices to keep the attention of the audience, but that is not introducing evidence in a courtroom. That is simply a way to frame an argument. So if this kind of technology remains at that level, probably can be managed, can be handled with the same instruments and also with the same rules that are in place for oral arguments. It's much more problematic when these audio videos, these images, tend to be introduced as substantive evidence, so as something which really has a probative value in respect to the issue which is at stake. And so in this case we are also having not so many regulation though, but case law, and in principle judges still enjoy a lot of discretion in evaluating whether this particular visual device, visual piece is prejudicial, so the probative value is overwhelmed by the possible misleading effect of the jury. But of course, we also need a lot of literacy. We need to know how to read and how to evaluate these new forms of representation of reality. And someone says, well, but the jury knows how to do it, because since they are lay people, and since they are used in everyday life to evaluate the correspondence to reality, for example, of TV fiction, they have very good instruments to apprise, to evaluate what is really reliable and what is not in this visual representation of, which arrives through new technologies. So paradoxically, the fact that they are lay people is an advantage, because it gives you some kind of guarantee that they will be able to evaluate the probative value, knowing perfectly how to separate, the frame, as I said before. So how to separate representation from reality, how to elaborate the meaning of what they are seeing. There is also a completely different area which I think is very interesting, and has little to do with what I previously called the visual culture, and starts with the idea of visual thinking. So here, our analysis is not limited to images, pictures, videos, audios, and these kind of things, but has to do with the very idea of visual thinking. So visual thinking, we use visual thinking all the time, actually. Many words are just the result of visual thinking. And the very basic word idea, which is very conceptual, is still very visual, since it comes from the idea of eidos in Old Greek, which is linked to the verb to see. So, especially in Western cultures, visuality is at the very base of our way of conceiving reality. And so let's see how normative systems and the criminal law in particular relate to this idea of visual thinking. And if you know a little bit criminal law, you know that very often the description of the rules of conduct, of the way people should behave, the definition of offenses, like murder, like larceny, like burglary, and so on, they are defined, these crimes are defined in a very figurative narrative. So you see that language communicates the development of something which has iconographic nature. If we read, for example, the definition of burglary, you see, is the narrative of burglary, right? That's the image of someone who is breaking and entering the house of another, in the night time with intent to commit a felony therein. So you can think it of in terms of a video clip. It narrates a micro-drama in which you see someone moving and doing something, doing an action. And so this is very visual. It's very visual. We will compare it with the way other branches of the law write their rules, and we'll see that here we have a very high degree of visuality. The same is with larceny, someone who's taking and carrying away the property belonging to another. You see, this person moving, entering, and taking the thing and bringing the thing, taking the thing somewhere else. The same is with robbery. Here I took common law definitions, which are even more iconographic than the one that you see in statutes today. Since they are more traditional and more linked to a society which was capable of, catching just in one icon, just in one very precise description, a sense of a crime. So, the same is for all crimes. And I mention adultery because we will see it also in a real picture that I will show you in a few minutes. And here too, it's someone who engages in sexual intercourse with another person at the time when he has a living spouse, and so on. You can read it. Very visual. So this is very different from what other branches of the law do. I just, reported here a provision from the California Civil Code which has to do with the elements of contact. So something which is very basic for private law, for civil. And, is an agreement to do or not to do a certain thing, and then the elements. Capacity of the parties, consent, lawful object, a sufficient cause or consideration. It's not very visual. It's just a list of concepts which find their definition probably in the case law or in the books of scholars or wherever, but it's not visual. You could have them on one of those old iPods, the one without any screen, where you could listen to music without watching anything. This is not visual. Okay, now this is interesting. When I spoke about normative systems at the beginning, and I said, well, this relation is not limited to the law. We just saw how there are branches of the law which are not visual. However, there are other normative systems, especially morals and the system of social rules, which are sometimes very visual. And for example, that the Ten Commandments are not really 10, but 613 according to the Bible, and also, and then I will report some of them, but then you have many moral, religious, and social prescriptions concerning, for example, sexual promiscuity, specific sexual acts between consenting adults, food rules concerning the management of impurity and dirt. These are a very, very, very interesting set of rules, and also polite rules as letting a woman pass first. These are always very, very visual. This is something in Old English taken from the Bibles. For example, just read this one, which has to do with the prohibition for a woman to wear man's clothes, and vice versa. Again, is a moral rule of conduct, very, very visual. So, the criminal law is so visual that at one point someone tried to make pictures out of it. So, to go back from language to pictures. The language of the criminal law is so visual, is so figurative, that it is possible to illustrate the list of crimes. So to go back from language to pictures. So this is blasphemy. I will show you, a number of pictures. And of course, we cannot, touch this topic, but there is also a different way to communicate the prohibition if you use words and if you use images. Many times when you use a picture, an image, you are not sure about what is really essential and what is simply a feature that the painter decided to add in the picture. Anyway, this is blasphemy. This is, revolting against the king. This is escaping from prison. This is adultery. Now, you see that there is a man sleeping, and there is another one who enters, and there is a mouse. So the mouse, I don't think, plays any role. And about other things you can discuss. For example, the man is a rich man, probably because you see he's really well dressed. Is that important? Does it add something to, the blameworthiness of that conduct? This is, I think I can translate it with condoning adultery. You see, the husband is in front of the fireplace, and he knows that his wife is with that one. And again, you can speculate whether it is important than, the man is, dressed with elegant clothes while the other one seems a little bit poor. If you have a definition given by words, you have a more precise fine-tuning of what the law means. With images, you have at first sight, a clear idea, but if you enter into interpretation of meaning, it's much more debatable. Because you never know what is really essential and what is part of the figurative representation of the... This is a negligent homicide. And you have 2 or 3 kinds. The one on the roof, the one counting the tree, and I think the most. Yeah. This is a form of kidnapping. It's not really rape. It's a form of kidnapping which leads to abduction of these women. This is cattle rustling. Mm-hmm. And this is very visual, of course. It's just, invading the property of another person with these wheels. This is a form of larceny. It's a theft, from the pocket. This is arson. I'm sorry about the quality because it's not constant. Some pictures are clear, others are not so much. These are all taken from that book that I mentioned before. And this is a kind of strange crime that we don't have anymore as such. And this, larceny with arson. So you have arson and larceny in the context of an arson. This is rape. And this is fornication. This is assaulting people on the highway. In the highway, in the old sense. And this is, altering damaging the banks of a river. This is another form of robbery. And this is a violation of a sepulchre. We are almost at the end. Here, they had some problems, and this is incest. It's not very easy to render the image of an incest. So you have to add something in words in order to, mark the roles of the people acting. Okay, so I think I have other 5 minutes, 10 minutes. Yeah. What is the function, and how comes that criminal law is so visual? Well, one reason is that criminal law addresses the general public, addresses every citizen. So, while we are here now, we have a bunch of private law rules which sleep in the books. And they will sleep until the day we need them, until the day we need to form a valid testament or a valid contract. The rules are in the books. Criminal law prescriptions are always in standby, they are always active. They are always binding over us. So they address the general public, as we know. Prohibition to murder, to assault, to rape. They are always there. They're always active on us. So they have to reach the ordinary people, the ordinary citizens. And that's why the problem of communication is much more serious than in many other branches of the law. And the use of realistic language is no doubt a way to reach the ordinary citizen. And it's also a good compromise, a good way, to have something in common between the ordinary citizen on the one hand and the adjudicators on the other hand. So think of when we use words, just technical words, you have citizens that can understand until a certain point, and you have judges that need more specialized language, more technical language. So you have to find a balance between the two needs. And images are often a good way to balance, because they are easy to understand from the general public, but at the same time, they are a quite good way to communicate, what you really mean. What is the essence of that crime? What is the basic shape of that conduct? And here we come to the origin of this way of describing criminal offenses, because we know the function. The function is to ease communication of the rule of conduct. But how is it possible to develop this very visual branch of the law, this very visual regulation? And the basic idea is that you have some shared paradigm of aggression which the community think is bad, evil, unlawful. So when the typologies of crimes like larceny, burglary, you have a shared image of what is wrong, what kind of conduct is wrong, what kind of conduct embeds in itself the notion of evil. So you associate, you combine constantly that shape of conduct with unlawfulness, with evil, with the idea of wrong. So the fact of entering into the space which belonged to another person in order to take a piece of property from that protected space and take that property into your own protected space. That paradigm of conduct, that shape, is intuitively associated with wrongdoing. So it's something that takes place in one particular context. So it has basically, a unity of space, of time, and is a single transaction. But it is a single transaction which has a manifest meaning of unlawfulness. So when it happens, it's clear that something wrong is happening. So this is at the very base. This is at the very origin of the history of different crimes. But today it's not possible. It's not easy to to generate crimes this way. So today we are experiencing a time of crisis for the iconic criminal law, from visual criminal law. If you think of new crimes, starting from tax evasion to some form of violation of regulation concerning a sector of the economy, or if you think in the U.S. of crimes like RICO crimes, which is a legislation against organized crimes, in which the criminality derives from the commission of a number of crimes in a given time frame, being associated with an enterprise which acts to a pattern of racketeering activity. It's all an adding up. It's a list of things, and you have to go, through the entire list, adding. So there is no icon which gives you an idea of what that crime is. And it's very difficult. So this is the end of my conversation tonight. This is the very problem today, to regain in some way this visual connotation, this visual component of normative systems, we could say, of the criminal law in the first place, but also of systems which, in any case, impose or advise or suggest rules of conduct. We do not associate anymore constantly shapes and meaning. A given conduct can be very ambiguous. In our sensitivities, they can mean many, many different things. We lost this, very structured connection between shapes of conduct and meaning. So what is possible? Well, as you see, and here we are going back to the new technology, because one possibility that we have in order to regain visuality, in the criminal law, but also, not in the criminal procedure, not in trials. I'm talking about criminal law now. I'm talking about rules of conduct. Is to be able, thanks to the new technologies, thanks, for example, to the augmented reality, to enrich the shapes of the representation, adding information which are not directly present into what we are watching. For example, if you are familiar with every application of a smartphone which tells you where restaurants are, or so you target a street in Florence, and of course reality renders also only the street, the houses, but with the augmented reality you can enrich that shape and put much more information, but this information is to a certain extent visual or is part of a vision. So one possibility is to work in this perspective and to try to regain visuality in the elaboration and drafting of rules of conduct, enriching the shapes of the world with additional information. Of course, this is also very risky because it depends who uses this technology, and sometimes you have information that you want to remain private, for example, you don't want to be known, and so it's very controversial because it also depends who uses this new visuality. If you just put them in a data bank, if you address them to ordinary citizens in order to show them what they can do and what they cannot, or if you give this screen, for example, to the cops on the street, which know exactly what are the criminal records of everybody, and so they can apprise a probable cause, knowing the records, the criminal records of everyone that is within the screen. Well, this is a completely different view, and I really don't have time to develop this view here, but just very few words. You know that visuality usually is connected to the way we are used to see it after the Renaissance. And so you have a vanishing point which is within the picture. So you are a spectator, you watch the picture from outside, and representation is the representation of something which is completely separated from you. This is an icon by Andrei Rublev. He's a Russian icon painter. And it's a completely different way of conceiving the perspective. This is called the reversed perspective. Since you see the vanishing point is the observer. So you don't watch the picture from outside, and you do not watch a scene, an image which is a dead image, but you interact with the image, since the vanishing point, you see, it comes and you are the vanishing point. So this is a metaphor again, and we are linking, images, language, law, and everything. But the alternative is to accept a more significant role of the interpreter. So to accept the fact that today criminal law cannot be visual anymore, cannot represent objectively a particular portion of reality, telling us, you see, that is the role of conduct. But simply, criminal law norms, like it's happening in many other respects, has to involve the interpreter. So the search of meaning is not the result of watching, but is a result of interacting with image. Well, I think...